Good day, ma'am. Good day, everyone. In this video, we are going to tackle about the section 2 and 3 of the chapter 4. By the way, my name is Visal I. Corporal, who will gonna tackle about the section 2, loss of a thing due. And I'm Maria Pacific. I will tackle the section 3, which is condemnation or mission of death. So one of the important section of the chapter 4, extinguishment of obligation, is the section 2, loss of the thing due. It consists 8 articles from Article 1262 to 1269. So before I tackle the first article, let us know what is lost in the obligation. So lost doesn't just limit our ideas about just mawa ang usa ka butang. It deals with a wider and deeper concept in the obligation. So it is understood that the thing is lost when it perishes or goes out of commerce or disappears in such a way that its existence is unknown or cannot be recovered. So the thing is considered lost kuno if ang usa ka butang is ma-end iyang existence, mawa iyang existence, at the same time dili na pud si Jama recovered. That is the concept of lost in obligation. So in Article 1262, an obligation which consists in a delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. When by law or stipulation the obligation is liable even for prodigious event, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. So in this article, if mawa ang specific thing or determinate thing, ma-extinguish na ang obligation sa obligor. But always remember that this has also a exception sa and babasa sa just sa second paragraph of this article, which is when the law so provides and the stipulation so provides and the nature of obligation requires assumption of risk. So to fully understand this statement, let's have an example. So the example is X promised to deliver Y a particular bicycle on December 31, 2020. But the said bicycle was lost on December 25, 2020 because of a typhoon. So ang pangutana, liable pa ba si X? So the answer is no. The obligation of X na-extinguish na ang obligation sa X because nawa ang determinate thing without his fault. Kay nawa man siya tungod sa typhoon. And before he has incurred in delay. Kaya before pamantos siya ma-deliver unta ini ka December 31, nawa naman siya pagka December 25. So, ang obligation sa X na extinguished na. Article 1263, Loss of a Generic Thing. So at the previous article 1262, we talk about a specific thing, the effect kung mawa ang determinate or specific thing dito sa obligor. So diba dito sa 1262 is ma-extinguish na ang obligation sa obligor. So here in the 1263, we will gonna tackle of what is the effect kung ang generic thing na pud ang mawa. So in Article 1263, in an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So under Article 1263, kung ang generic thing na kuno ang mawa, dili kuno ma-extinguish ang obligation ni obligor. So naghapon ni CJ exception. So are you familiar with the limited generic? So let me give you an example about the limited generic. So example of this is X obliged himself to give Y a 100 sacks of rice from December 2020 harvest. However, all of those were lost because of a typhoon. So, is X still liable? No. Dili na liable si X because specific kato kibali ang katong rice kaysa 2020 harvest raman ang katong rice dapat. So, nawa man ang nawa naman tungod sa typhoon, so dili na liable ang obligor. Pero kung ang statement is X X obliged himself to give 100 sacks of rice to Y, kung dila ra takutob, then liable gihapon si X because in that case, generic naman ang concept sa paghatag og rice. So that is the Article 1263. Article 1264. The courts shall determine whether under the circumstances the partial loss of the object of the obligation is so important as to extinguish the obligation. To fully understand this statement, let me give you an example. So, example, X obliged himself to deliver Y a motorcycle with the plate number ABC123. Subsequently, the two tires and the engine of the motorcycle were lost through a typhoon. So in this case, ang court na mag-decide if the two tires o katong engine is so important makahato para sa motorcycle. So, kung ilang ma-determine na importante ang two tires o ang engine, then the obligation of the obligor will be extinguished. But they will determine that those partial loss of the object is not considered as a total loss, kay di man siya importante, then the obligation will not be extinguished. So the general rule of this article is that the partial loss of the object of the obligation does not extinguish the obligation. So kung partial loss ra ang nawa sa usa ka butang, then dili na siya ma-extinguish. Pero ang naghapon na siya exception. So when the courts determine na ang katong partial loss is so important, then it will be considered as a total loss. So that is the Article 1264. Article 1265. Whenever the thing is lost in the possession of a debtor, it shall be presumed that the loss was due to his fault unless there is a proof that to the contrary, and without prejudice of the provision of the Article 1165. This presumption does not apply in case of earthquake, flood, storm, and other natural calamities. So in this article, kung mawa ko ng usa ka butang in the position of the debtor, then presumed that the loss was due to his fault na sa debtor, pero not that totally at fault na ang debtor. Presumption pa na nga siya ang sa. So, pwede pa na niya ma-overcome nga maingog mahimong di na niya sa if he or she has a proof na nawa ang usa ka butang tungod sa mga natural calamity o dili tungod sa man-made. So, let's have an example. Example, si X naghuwam og cellphone ni Y. But, during sa iyang pagpanghuwam, nawa ang cellphone. So, si debtor, miingon ni si Johnny Y na, ingon si X ni Y na, Y, nawala ang cellphone, di na ho sa. So, in that case, di pa nato ma-extinguish ang obligation ni debtor. Kay, in the Article 1265, kay nawa man niya ang cellphone in his position as a debtor, then he was presumed at fault na in that case. So he can overcome it to show proof or to give reason na nawa ang cellphone in a natural calamity like earthquake, flood, storm, or etc. Pero if man-made ra gani ang rason nga nung nawa ang cellphone, then the debtor or si X is liable to give the obligation. And that is in the Article 1265. Article 1266. The debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. So, what is legally or physically impossible? So, let me give you an example. So physically impossible, example, si X obliged himself to build a commercial building for Y. But then, A week after that, namatay si X. Then X will no longer be able to build a commercial building for Y since namatay naman si Ja. So the obligation shall be extinguished. So another example for legally impossible, mura gihapon ang situation which is X obliged himself to build a commercial building for Y, but then the government refuses to give them a building permit because kanang ang area nga ila dapat tukuran is na-declared na sa law nga mahimo na tong residential zone, which is not di na pwede tukuran og commercial building. Hindi naman to commercial zone dito, commercial building. So, ang dito, pang residential zone dapat siya. So, ang ilang supposedly magtukod nga commercial building is ma-extinguish na kay it is legally impossible. So, that is the Article 1266. Article 1267. When the service has become so difficult as to manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. So let's have an example. Example, there is a construction of the road. So in the middle of the construction of the road, an earthquake suddenly happens. Sa kakusog sa earthquake, inabot na sa point na na-change na ang condition of the land. So the the construction are still possible, but then it is very dangerous now for life and property. It is something that is not contemplated by both parties na sa possible nga mahitabo. So, the obligation will be extinguished. But then, take note na the one party must ask for a relief, and that is the Article 1267. Article 1268. When the death of the thing certain and determinate proceeds from a criminal offence, the debtor shall not be exempted from the payment of its price, whatever be the cause of the loss, unless the thing has having been offered by him to the person who should receive it and latter refused without justification to accept it. So in Article 1268, so kung mawa ang sa kabutang ni obligor without his fault, but then his obligation to deliver arose from the criminal offense, then ang iyang obligation cannot be extinguished or liable gihapon siya sa iyang obligation. So let's have an example. Example si X, iyang gikawat ang car ni Y. In that case, na-order si X nga iuli niya ang car ni Y. But then before pa man niya ma-deliver ang car, is nasulog ilang Y at pinaapil ang car ni Y. And then, in that case, dili ma-extinguish ang obligation ni X because his obligation to deliver that thing is arose from criminal offense. So, obliged gihapon si Ja or liable gihapon si obligor sa iyang obligation. So, that is the Article 1268. The last article of the Section 2, Article 1269. The obligation has been extinguished by the loss of thing, the creditor shall have the rights of action without the debtor may have against the third person by reasons of the loss. So, as you noticed the previous lesson, we only have X and Y. Now we have the third person na, which is CZ. So let's have an example. So X promised to deliver a watch to Y, but then gikuha to ni Z ang watch nga i-deliver unta ni X ni Y. And then, nawa ni Z ang watch. So, si X is not, di na siya liable. Na-extinguish na ang obligation, then ang obligation mo napasa na dito ni Z. Then si X, di na siya mo go after dito ni Y, kay wala naman siya obligation ni Y. So, si Z na ang obligation. So, para maprotektahan ang right ni Y, si Y na siya right, according to the Article 1268, na right si Y mo su ni Z, which is si Z na ang na ay obligation to give dipuni y. So that is the Article 1269. So Article 1270, condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly. One and the other kind shall be subject to the rule which govern inofficious donation. Express condonation shall furthermore comply with the forms of donation. So, condonation or remission is a kind of donation that requires acceptance of the debtor. So, there are requisites of condonation or remission. First, it must be gratuitous. Second, it must be accepted by the debtor. Third, the obligation must be demandable. Fourth, the parties must have capacity. Fifth, the condonation must not be inefficacious or excessive. And the condonation must comply with the form of donation. If it is an express donation, it requires formalities. So, inefficacious donation. A donation may be reduced for being inefficacious if the parties give or receive more than what they may give or receive by will. So, it impairs the legitime of compulsory case. So, forms of donation. The forms of donation are provided in Article 748 and 749. Article 748, the donation of a movable may be made orally or in a written. So, Article 749, in order that the donation of an immovable may be valid, it must be made in a public documentation. So, kinds of remission or donation. So, first, as a form, express and implied. So, express, it is being made either verbally or in a written. So, implied, conduct of language. Second is as the context. Total is when the entire obligation is extinguished, and partial is refers only to the principal or the accessory of obligation. So example is nangutang siya and then katong lang dyan mabayad. So it's partial. So third is as the constitution. Inter vivos, it will take effect during the lifetime of the donor. And mortis quasi, it will take effect upon the death of the donor. So makita na siya sa last will and testament sa donor. Article 1271, the delivery of a private documents evidencing a credit made voluntarily by the creditor to the debtor implies the renunciation of the action which the former had against the latter. If in order to nullify this waiver, it should be claimed to the inofficious, the debtor and his heirs may uphold it by providing the delivery of the documents was made in virtue or payment of the debt. So, this article speaks about private documents. It is presumed that in case the documents of indebtedness is voluntarily delivered by the creditor. Article 1272, whenever the private documents in where the debt appears is found on the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily unless the contrary is proved. So, ang Article 1272 is superior sa 1271 which is related na silang duha. Article 1273, the renunciation of the principal debt shall extinguish the accessory obligation, but the waiver of the latter shall leave the former in force. So, since the accessory follows the principal obligation, meaning if The principal obligation renounce also the accessory obligation will ma-renounce po siya. So, if balis siya, if ang accessory obligation is ma-renounce, it means the principal obligation it still exists even without the accessory obligation. So, example, si A nangutang ni B. Then, si C ang guarantor ni A para makautang si ni B. If si B mo renounce nga si A mao ang principal obligation, if i renounce ang principal obligation, it means ma-renounce po ang accessory obligation which is si guarantor. If ang ikuan ra ni B, ang i-renounce ni J ang accessory obligation which is ang guarantor, then magpabilin gyapon si principal obligation nga mobayad sa iyang obligation. Article 1274. It is presumed that the accessory obligation of pledge has been remitted when the things pledged after its delivery to the creditor, it found it the possession of the debtor or of a third person who owns the thing. This article note that under the Article 1274, only the accessory obligation of pledge. So, example, si A nangutang ni B, and then ang iyang guarantor is ijang gisangla, ijang alahas ni didto ni B. And then if si B ijang voluntary delivery ni ijang katong gisangla nga alahas, wa na nagpasabot nga di na bayaran ni A ang ijang obligation ni B. So that would be all from the section 2 to the section 3 of the chapter 4, Extinguishment of Obligation. So I hope you learned something from this discussion. My partner and I are so grateful for having your time watching this video. Thank you and God bless you all.